what's very peculiar to Guyana is we're the only ones in the English-speaking Caribbean for sure, and one of 3 countries in the world in 2015 to have laws which criminalize cross-dressing. Some of the other Caribbean countries actually have what is called a carnival ordinance, which says, like Grenada, which actually says you shouldn't cross-dress during carnival, which makes no sense because in the Caribbean that's the time when it's culturally accepted. But we're the only ones that have something in our criminal laws to say cross-dressing is illegal. Guyana, that is, in the entire region. The other 2 countries in the world which still have laws like this, the places that had these laws a long time ago, like in Latin America and so on. But the other 2 countries in the world which still have laws like this are Malaysia and Nigeria. And in those countries, it's under the Sharia law. Those are theocratic states where there's Muslim law, right? Ghana has this in our regular, we're not a theocratic state, we have this in our regular secular laws. In Guyana specifically, it's under the Summary Jurisdiction Offences Act. And that brings me to the question I want to ask Oliver. So we've had a partial victory at the level of Guyana's Constitutional Court. Justice Ian Chan in September 2013 ruled that cross-dressing is not a crime unless it's for an improper purpose. The term improper purpose is actually in the legislation itself, and he didn't say what it means, he didn't explain it at all, and he didn't say what quote-unquote improper purpose or improper purposes gave rise to the arrest when you, Peaches, Falatama, and the others were arrested in February of 2009 and held over a weekend and faced a great number of human rights violations. Now we've appealed the judgment, we're waiting on a date for appeal. How do you feel about the prospects for appeal, that we would get a full victory in this case?
Just, good evening, but just to buffle the brains about what you just said. I had actually said about improper purpose, and we know because many times as the person directly getting involved in transgender, directly transgender, who are transgender, the main word that they actually get into is sex work. And we know for sex work by itself, it's the solicitation around sex work is it also illegal. So one of the things is many things could be illegal improper purpose. You could stand in at a particular in front of a business place and majority sex work at a particular location, do around corners or street, and majority of those times are business place who transfer by the next group, maybe some other business during the day and then in the night they transfer to sex business or whatever the case may be. And by standing in front of a business place could be something improper purpose, because you could be charged or lighter, or perhaps you may be charged or waiting for committing a felony or whatever. So by itself, I said an improper purpose, we didn't know what is an improper purpose rule, and because we take into the fact that many trans are forced into sex work because they're not having a level playing field to have jobs and such forth, and realize where they actually go to apply those traits, maybe at any time could be charged for improper purpose. So we wanted to know directly what it means by an improper purpose and what is in his judgment to say what is an improper purpose.
Right. Well, I think you hit the nail on the head there. I think there's, if you try to read between the lines, and this is really reading between the lines in Ian Chan's September 2013 decision, there's a subtext in my own view that he was referring to sex work as being an improper purpose. But which makes it a lot more complicated, makes the issue a lot more complicated and nuanced, as Oliver shared. Because we have in Guyana a situation where actual prostitution, as it's called in the law, is not illegal, but there's several offenses around and involved in sex work which are illegal, like living off the earnings, like running a brothel, soliciting in public, like public way or public place and that sort of thing and so on, but not the actual act itself of sex work. But they've criminalized so many of the offenses that for sex workers, the environment becomes completely unsafe. I always describe it as an occupational health and rights issue. Because if you don't have protections, the industry you work in is criminalized. How do you seek protection from the police when you work in what is essentially a criminal enterprise? Everything around you is criminalized. The places that you go to meet clients, the people who work with you, who might manage your affairs, and so on and so on. All of that is criminalized. So how do you feel safe, accessing justice, and that sort of thing? So first and foremost, to me, decriminalization of sex work is an issue of occupational health and safety and rights. And I think you really hit the nail on the head there about what is being implied about what might be an improper purpose. But it can't be just the legal context of sex work, because like I'm saying, actual sex work is illegal. And I think the other very important point that you made is the underlying cause, and we want to do some more research in this area, the underlying cause of why so many transgender people, disproportionately, so many transgender people are involved in sex work. And in our work, we're finding it's the transphobic bullying in schools, in the adolescent years when people start to transition and they start to manifest all of that. They're bullied, they're beaten, they face violence, and they drop out of school. You drop out of school, you have no CXCs, what you gonna do? What becomes your means of earning, of surviving, of making an honest living? You know, it's a huge pull factor towards getting into sex work. And that's why so many transgender people are disproportionately, like you're saying, involved in sex work.